what happens between now and the trial start date?
Well, normally what would happen next is the companies would file an answer to the Department of Justice's complaint, but they jumped in and did that right away. So that's finished. So most of what's going to go on between now and then is additional discovery. That is the collection of data, documents, and deposition testimony of various people in the industry. I know it's kind of remarkable that the Department of Justice might need to continue to do more discovery here when they've already been investigating for a year, but they have said there is more that they think they need in order to go to trial on this case. And of course, the companies themselves haven't really engaged in that kind of investigation at all and will be seeking documents from the Department of Justice as well as possibly other third parties.
How many days is the trial likely to last?
Well, the judge here said he estimated about 3 weeks. And I took a look at the last 3 trials in which the Department of Justice was challenging a deal. The last one being about a year ago. It was the merger of 2 radioactive waste disposal companies. And in that case, the trial lasted just a couple weeks. I've seen them last about 4 weeks, 2 weeks to 4 weeks. This judge estimated about 3 weeks, so right down in the middle.
So is there a possibility that this case could settle before it goes to trial?
You know, settlement talks can be ongoing at any time in any litigation. They can occur, you know, in the middle of trial, they can occur the eve of trial or right at the end of trial. In this case, I imagine the Department of Justice and the companies may talk a little bit, but it just seems like they're at an impasse, and I'm not really sure how that impasse can be bridged. You know, if the Department of Justice is looking for structural remedy, as in selling off assets like Turner or DirecTV, and the companies are only willing to engage in behavioral remedies, which would regulate their conduct after they've merged, I don't see what the middle ground is there, and it doesn't look like a settlement can be reached.
Now, Jennifer, I understand you have closely looked at arguments on both sides. Who's got the better case?
You know, my feeling still here is that the companies have the better case. I think the Department of Justice is sort of going against their own guidelines, going against, I wouldn't call it precedent because it's not technically precedent, but going against the practice of both the Department of Justice and the Federal Trade Commission for about the last 40 years in their treatment of vertical mergers. And in their treatment of the pro-competitive effects of those mergers, as well as the kind of remedies they enter. Where vertical deals like this one, which is not combining competitors, have raised antitrust harms in the past, that's usually been remedied with behavioral conditions like the companies have offered in this case.
So, you know, does that lead you to believe this is politically motivated?
You know, I think that is really just a difficult call to make, and I just can't say, because there is validity and feasibility in the Department of Justice's arguments. Vertical deals can raise the kinds of harms that the Department of Justice is alleging here. And it really comes down to what the economic analysis looks like, and you know, we'd really have to get into the weeds to understand that. And we don't know what their economists have done and what those studies look like. But what they have asked is whether there's a long-term profitability, whether it will be profitable in the long term for the companies to engage in a strategy where they withhold their content from other distributors, even if they take a short-term hit by doing that. So it's really going to come down to that economic analysis and what the company's documents say.